So what happened to the buyer's washer and dryer? This is a common problem in real estate, and it happens a lot more than people think. It's actually ridiculous. This is one issue that a buyer and seller should never ever have to deal with. And the only reason it's even an issue, the only reason it even comes up is because one of the agents screwed up. One of the agents was sloppy and dropped the ball. So here's the scenario. The day before closing, the buyers and the buyer's agent are doing their final walkthrough on the property. Now in this scenario, the sellers have actually already moved out. So the house is vacant, the house is clean, they left the keys, all the materials on the counters. The buyers are very excited, they're happy, they're closing on their new home tomorrow, everything's great, wonderful. They walk out to the garage and they notice that the washer and dryer are gone. The buyers are under the impression that the washer and dryer were part of the deal. Obviously, the sellers were under the impression that the washer and dryer were not part of the deal. This happens all the time because of miscommunication. One party is thinking one thing, the other party is thinking another. That's what's crazy. This should never be a communication issue. This is strictly a contract issue, or better yet, a lack of knowledge issue. Well, by this time, the buyer's agent is frantically looking online to pull up the MLS in front of the buyers to prove that it was in there, it was in the MLS and they showed the property. Guess what? It now says that the washer and dryer do not convey. At the bottom of the MLS sheet, there is no mention of the washer and dryer in the appliance section. Well, the agent feels confident it was in there when they showed the property. Lucky for them, they actually printed a copy of it the day they showed the property. They kept it in their file. So they pull it up, and lo and behold, the comment section even mentions how new the appliances and the washer and dryer were. It also has the washer and dryer flagged in the appliance section on the bottom of the MLS. So now the buyer's agent is very happy because they feel like they're in the right. He tells the buyers, you know, you can do whatever you want. We're not getting these back because the sellers have already moved off. They're out of town or whatever. So they owe you a washer and dryer. So it's kind of up to you what you want to do. So the buyers are feeling confident that the seller owes them a washer and dryer. They go home, they start looking online to find a comparable unit from Lowe's or Home Depot. Luckily, they have photos of it so they can figure out what it was because they were new. A couple hours down the road, the listing agent gets an addendum and an email from the buyer's agent requesting a credit for a certain dollar amount to replace the washer and dryer because it was owed to them because it was taken from the property when it was listed in the MLS when they showed the property. That part is true. It was in the MLS when they showed the property. But the big question, was the conveyance of the washer and dryer written in the contract? And the answer is no, it was not. Here in the state of Florida, we have two different sales contracts. One is called the FAR bar contract, and the other one's called the CRISP contract. Now, the FAR bar contract is used a minimum 70% of the time. Rarely do I ever see a contract that's not a FAR bar contract. Both of our Florida contracts have different language. Well, guess what? The FAR bar contract that this agent used does not have anything in the pre-language about the washer and dryer. Nothing. The washer and dryer conveyance was not written in this contract, so there's no mention of the washer and dryer in the contract at all. So the listing agent just happened to change the MLS to reflect that the washer and dryer were no longer part of the deal 2 hours after the buyer's agent pulled and printed a copy of their MLS sheet. They received an offer over 8 hours later with no mention of the washer and dryer in the contract. So nothing was even thought about the washer and dryer. That's exactly how this situation happens right there. Something you would think never would happen. And if the agent would have simply either, one of two things, either used the other contract because the CRISP contract has the washer and dryer written in the pre-language on the first page of the contract. The FAR bar does not. So most agents using the FAR bar contract have to write the washer and dryer in the contract or it is not going to convey legally. And that's the whole problem. Agents think that because it's in the MLS, that means it is part of the sale. And even though the intentions are there for that, usually, that's just not the case. And that's not the way the rules or the law works. I want to play a clip of this video that I found, and I think it's a broker from California, and they're answering this exact question. And the answer to me is right on point, and it's actually from an attorney.
Here's the question. The MLS provides that the washer and dryer are conveyed with the property, but the purchase contract made no specific mention of it. And after the closing, the washer dryer were gone. Does the client have legal grounds to claim the washer dryer?
Okay, so you already know the answer to that, and the answer is no.
The answer, according to our legal information line attorney, is unfortunately, this happens all the time and it is sloppy work.
Sloppy work. And that's what I said kind of in the beginning of the video. The only reason this situation happens is from sloppy work.
Representations in MLS create an expectation, and the purchase contract needs to parallel that. Otherwise, the stage is set for a dispute. Contract law includes the four corner rules, which basically limits outside stuff from contradicting the terms the parties agreed to within the contract. This is why it's so important to include all promises and expectations in the written contract, which is where a judge will look at first. Remember, at the end of the day, the licensee's duties include the exercise of reasonable skill and care. More importantly, MLS is merely considered an advertisement, so simply attaching an MLS sheet to an offer is not the same as including language in the actual contract.
Okay, this is a very good point that I forgot to bring up, but a lot of times agents will have buyers initial the copy of the MLS sheet that they pulled when they're showing the property. So everything in the MLS is, noted by the buyer. What they're saying, even though I think that helps because that way everyone is on the same page, and that's all you want. You want everybody on the same page. And I think sending over a copy of the MLS does just a really good job to make sure nothing's changed. Because if something's changed and it affects the buyer in in some form or fashion, then something's got to be done about it. It's got to be addressed.
It is all too common, the failure to account for the washer dryer with specificities such as model number, color, etc. in the contract results in an agent paying for a replacement out of pocket to avoid being sued or summoned before the division. To resolve the matter, the agent and parties would proceed to mediate or go to small claims court.
Okay, I'm going to wrap this up, but before I do, I'm going to show you one more thing. This is an article that was written by an associate general counsel for the Florida Association of Realtors. It's on their website. I'll put a link below just so you can look at the article if you want. This sums up this whole problem perfectly. The MLS property description says the property includes the washer and dryer, however, the contract does not. A large percentage of legal hotline callers ask this question, does it stay or go? One Florida realtor's legal hotline question that seems to be asked over and over again concerns items or property itemized in the multiple listing service, the MLS, that don't also appear in the contract itself. In most cases, the call involves an upset buyer right before closing that did a final walkthrough and discovered some missing items. This is the biggest point of this article. It is very important for realtors to understand that just because something is listed in the MLS description, it doesn't mean that item is being conveyed in the sale. Remember that the contract governs the parties, not the multiple listing service, not the MLS. Make sure the contract form you choose either includes the desired item in the pre-printed language or you add it to the personal property section to make it part of the transaction. Taking extra time to clarify certain things in advance can benefit the parties and get everyone to a successful closing, which is the ultimate goal. And this is the best part of the entire article, which is 100% true. And it was in the MLS does not mean it was part of the contract. Okay, that's it, folks. I hope you appreciated the video. If you have any questions, leave them below. If you like or dislike, hit the thumb below. I appreciate it as always. Have a great day. Thanks.